Good afternoon. I welcome all of you to a really special event with Amy Coney Barrett, Associate Justice of the Supreme Court, for a conversation on her new book, Listening to the Law, Reflections on the Court and Constitution. And it's my pleasure to welcome her to Georgetown. And to all of you, to everyone here in this beautiful redone auditorium, it's special to remind us how special these kind of gatherings are for us to engage directly with those responsible for interpreting our nation's laws at the very highest level. At Georgetown Law since 2012, the Center for the Constitution has been an important place to engage issues of constitutional law and theory in bringing together students, scholars, and, as we will see today, Supreme Court justices. It fosters a deeper understanding of the significance, interpretation, and application of this founding document. As we engage in the insights of Justice Barrett, this is also a testament to the work of this center, the mission of Georgetown Law, and our newly formed Capitol campus, situated just blocks away from our nation's charters of freedom and from the Supreme Court. So let me now turn it over to Randy Barnett, JD, our Patrick Hotung Professor of Constitutional Law, a member of our faculty for almost 2 decades. He's authored 13 books and more than 150 scholarly articles, and has appeared in several documentaries on the U.S. Constitution. As you know, Professor Barnett serves as the founding director of the Georgetown Center for the Constitution, together with faculty co-director Stephanie Barclay. Professor Barnett.
Well, thank you so much for that introduction. You didn't come here to hear me. I am basically here to introduce the people you did come to hear. I've been asked to make the following announcement, however, and that is to please note that disruptive behavior may be subject to referral and action under the Student Code of Conduct, and that acting in such a manner can cause bar and character issues. Any disruptors will be promptly removed from the event. The one thing I do feel moved to say before I introduce the participants today is, since, as you just heard, I am the Patrick Hotung Professor of Constitutional Law, and the real Patrick Hotung is in the building here in the first row. And so I want to thank Patrick and his wife, Lisa, for their generosity to the Law Center, as well as to the Center for the Constitution. And thank you. I think one of the fringe benefits for Patrick is that if you search for his name on Google, all you come up with is Patrick Hotung, Professor of Constitutional Law. You cannot find anything about him, so it's a good way of sort of cleansing his online profile, which is by giving this chair. Okay, I'm here to introduce, first of all, Justice Amy Coney Barrett, who is the Associate Justice. She was born in New Orleans, Louisiana. She received her BA from Rhodes College and a JD from Notre Dame Law School. She served as law clerk for Justice Lawrence Silberman of the U.S. Court of Appeals for the D.C. Circuit, and for Justice Antonin Scalia of the Supreme Court of the United States, who spoke here about his book some years ago. After 2 years in private law practice, she became a law professor, joining the faculty of Notre Dame Law School in 2002. She was appointed a judge in the United States Court of Appeals for the Seventh Circuit in 2017, and in 2020 was nominated and confirmed as an Associate Justice of the Supreme Court. Interviewing her this morning or this afternoon is my colleague Stephanie Barclay. She's a professor of law, Georgetown Law School, the faculty co-director with me of the Georgetown Center for the Constitution. I can tell you that bringing her on board has transformed the Center for the Constitution. We do a whole lot more things than we used to do because she's here. She has served as a law clerk to Judge Randy Smith on the U.S. Court of Appeals for the Ninth Circuit, and to Justice Neil Gorsuch of the U.S. Supreme Court, and she clerked for Justice Gorsuch while she was on the faculty at Notre Dame. She graduated summa cum laude from BYU Law School and is currently completing her PhD in law at Oxford University. So please welcome to the stage Justice Barrett and Professor Barclay.
Well, thank you, Justice Barrett, for being with us. It's such a treat to have you here to speak to our Georgetown community about your book, Listening to the Law. You wrote about in the book that both as a professor and then when you became a judge on the Seventh Circuit, you would sometimes keep toys in your office and you would blend family life. Mm-hmm. And the kids would sometimes use your courtroom for mock trial practice. So I've got to ask, have they done mock trial practice at the Supreme Court?
They have not done mock trial practice at the Supreme Court. They have at the school my kids attend, where Professor Barclay's daughter is a classmate of one of my children. They do American history in their freshman year. They do a lot of reading. They read the Federalist Papers. And so both of my son's classes have come to the court and I've talked to them, about the court and the Federalist Papers, et cetera, but no mock trial. They do mock trial with their dad at our house.
Very fun. Your book highlights the story of your grandmother and her house, and that's a significant theme throughout the book. Can you talk a little bit about why that's important, why you have that framed in your office?
I open the book by describing a picture that I have framed on my desk of my great-grandmother's house. And I didn't know my great-grandmother. I actually had not seen her house until I was an adult. I'm from New Orleans, and my siblings and I rented a party bus on my dad's 70th birthday, and my parents are lifelong New Orleanians, so we went to special spots for them around the city, including my great-grandmother's house. We walked into this house, and it is a shotgun-style house. Like, you can stand on the front, open the front door, and you just see straight out the back. And it was very small. She had 13 children, and she lived in this house as a widow during the Great Depression, and this house was tiny. She took in relatives. She fed homeless men that came through the neighborhood. And when I looked at this house, I thought, we have 7 children. Our youngest has Down syndrome. And at the time we were in the house, he was little. He was about 3. And I was feeling very overwhelmed and very sorry for myself. And I thought, oh my goodness, look how much my great-grandmother fit in her life in this small space, how much she was able to handle. And I decided to frame the picture and keep it on my desk because it reminds me of what she was able to do and inspires me to be able to handle a very full life and stretch small resources to make it all happen.
Love that. I want to ask you about one other picture of a woman that's important to you. Can you talk about the portrait of Abigail Adams and what that means to you, why you have her hanging in chambers right now?
I have a portrait of Abigail Adams hanging above the fireplace in my office, in my chambers. And I chose it because, as I describe in the book, and as the center holds near and dear originalism, I wanted to have something from the founding era in my office because a lot of my time is spent interpreting the Constitution, applying the Constitution, thinking about the Constitution. But of course, there were no women at the Constitutional Convention, no women in the state ratifying conventions. So Abigail Adams, to my mind, is about the closest you can get to a woman founder because she consulted with her husband, John, about so many things, gave him advice about all manner of things having to do with the revolution and the beginning of the country, and complained in letters to him that women were not able to hold high offices or participate in government. And so I feel like her picture, I chose one. I actually initially chose the famous Gilbert Stuart one at the end of her life, and I traded it in for a one from her youth. It was actually before she married John, because I felt like that was a moment, it captured Abigail Adams looking out at her life when she wasn't quite sure what was going to happen yet, and the hope that she must have had. And I think about what she was a participant she participated in starting what we all now enjoy the fruits of, and think that while she was not able to participate in the government, in high offices of government, I am.
You can. That's a promise.
Yeah.
you're fulfilling. Yeah. So, talking about your time at the court with your colleagues, I thought one of the stories you shared in the book about something Justice Sotomayor did to make you feel welcome was meaningful and timely, given that we have Halloween coming up. So can you talk a little bit about that, and also some of the trepidation you felt going to the court, different than a normal job you explained, where you would be like recruited and hired and you know that your colleagues picked you. It's different when you're coming to the Supreme Court.
Yeah, you're thrust upon your colleagues. You know, they don't hire you, they don't recruit you, they have no say in who the president appoints and the Senate confirms to take the spot. It was the middle of COVID when I began, and so it was a very weird time, you know, and the court, people weren't around, arguments were being held remotely. And I just wasn't sure, you know, when you walk into a situation where your new colleagues never expressed any interest in having you, and had also lost Justice Ginsburg, you know, with whom they had served, many of them had served with for many, many years, you know, a friend and a longtime colleague, and then, you know, and here I was coming, and I was very touched. It was actually right around now, 5 years ago. We were approaching Halloween, and my husband had come up to be there for my swearing in. The chief administered the oath in one of the conference rooms at the court, with everyone in masks, socially distanced all over the conference room. And we went back.
Presumably Jesse could stand next to you.
Jesse did stand next to me, but when you see the picture, when you look at pictures of other justices being sworn in, for example, if you look at Justice Jackson's, the chief is standing at a normal distance, you know, holding up, but mine, we were standing quite far apart. And if you didn't know that it was during COVID, which, you know, I think it might be up on the Supreme Court website. If you didn't know it was during COVID, you would think, man, he really did not want her to come. But Justice Sotomayor is a very warm person. And she sent bags of Halloween candy up to my office because Jesse was leaving to head back to South Bend. I commuted the first year to take back for the kids. And that's something that Justice Sotomayor does for all the justices' children. I'm kind of the only one left who still has candy-consuming kids. But she brings bags of Halloween candy, and she did that for me, so.
And do you still have at the court the tradition where kids will go around and trick or treat at the court?
Yep.
That's coming up,
Yep,
right?
that's coming up. That's this week.
Will your kids come and trick or treat at all?
They do not come and trick or treat because it would be just too complicated for me with sports and after school stuff to get them over. And, you know, now the older ones are getting too cool for trick or treating.
Right. We're approaching that stage too. I'm trying to stretch it as long as possible. So there are other traditions at the court that I think you talk about are important for maintaining collegiality. And one of the lines that I really love from your book is you say, collegiality is an act of will. What do you mean by that? And can you tell us more about some of the traditions that you think are important to cultivating that sort of collegiality at the court?
Yeah, collegiality is an act of the will because you don't always feel like spending time with people. You don't always feel like being friends. And you discipline yourself to want to do it. You know, when I was growing up, we used to say, I am one of 7. And when I would get in a fight with one of my sisters, because there were 6 girls, 1 boy, when I would get in a fight with one of my sisters, you know, and my mom would come in to referee and she would say, now apologize. You know, I'd always say, but I'm not sorry. You know, I don't feel like apologizing. And they used to say, both of my parents, you know, forgiveness and apology are an act of the will. You don't wait to feel like it before you act on it. And I think that's true with collegiality. It has to be a matter of discipline. You discipline yourself to spend time with people, to assume the best. And at the court, we build in many mechanisms for trying to cultivate collegiality, and a lot of it has to do with time spent together. So we have lunch together. On the days that we have oral argument and conference, we go up, there's a justice's dining room, and we brown bag. One of my law clerks once asked me, so, like, you know, what does a cook make you, like, when you have, you know, lunch? I'm like, now I bring my yogurt and, you know, our granola bar, but we'll have lunch together. We do things like, you know, Justice Kavanaugh, as the most recent junior justice, threw a welcome party for me, and then I did so for Justice Jackson. We have court Christmas parties. We just build in ways. We have a handshake before we go on the bench at oral argument or when we arrive at conference. And all of those things are traditions that are built as ways to knit people together in a professional working environment where they can have affection and be collegial, because we're kind of locked into marriages, arranged marriages, with no prospect of divorce. So this is a long-lasting relationship, and it doesn't behoove anyone to make it a sour one.
Yeah. This is the party that you threw for Justice Jackson. I was very jealous of. You arranged Broadway singers to come perform some songs from Hamilton, right?
Mhm.
Very fun. And I think also that you were drawing on Justice Jackson as a fan of Broadway as well.
Yeah, Justice Jackson loves Broadway. She loves theater and musical theater. And I did some investigating and scouting. I wanted to do something that was something she would enjoy and also that was relevant to her personality. Justice Kavanaugh had done that for me. It was a New Orleans theme. So for Justice Jackson, I discovered Hamilton was her favorite musical. And so tracked down someone who was a Broadway performer who sang some of the songs for us after
just
dinner.
Like in your Rolodex? Just
Yeah, No, actually, it was through some connections. It was not a direct ask, but this person was honored and delighted to sing in honor of Justice Jackson. So it was a lovely event.
And the lunchtime conversations, you mentioned in your book that especially on particularly difficult days of a vote or argument, lunch can really be a golden opportunity to try and still have positive feelings with colleagues. Am I getting that right?
Yeah. Someone told me that it is most important to go to lunch on days after a difficult conference vote, because we do lunch on days of conference too. And I've really tried to keep that in mind, because I do think, those are the times when it's easy to let seeds of resentment take root or seeds of discord take root. It's kind of like, never let the sun set on your anger. If you go to bed mad, then it lingers the next morning when you wake up. So better to spend time right away and just put that behind you. And we have a rule of not discussing cases at lunch. It has to be, it can be related to things in the court, but not cases. We don't talk about the merits. And so it's an opportunity to put disagreements that are professional ones, that are really about the cases, that are really about the merits, that aren't personal, behind us. That too is an act of the will.
Something related to this is, you mentioned in the book how the media often is just focusing on 5-4 decisions, or like if you were just reading the headlines about the court, you might think that the vast majority of the decisions are 5-4 decisions. Can you speak a little bit to what
6-3 these days?
Or 6-3, yeah, 6-3. So speak a little bit to what the reality is like and the amount of unanimity that you and your colleagues are able to find at the court.
Yeah, I don't have, when I do, I'm the justice assigned to the Seventh Circuit. And so I usually look at the statistics and try to commit them to memory when I go in, because I do think this is an important point to make. I don't have the statistics at the tip of my tongue. But I believe last year there might have been 6 cases, don't hold me to that, but in the ballpark of 6, that broke down 6-3 by party of the appointing president. And that was about 10% of the vast majority, so call it roughly the other 90%, had all kinds of different configurations. And then we also have close to half of cases are unanimous or almost unanimous. So I think the narrative of a court kind of divided along the political lines of the party of the appointing president doesn't match the docket. And I also think, I was doing an interview for the book in the last couple of months, and the interviewer said, yeah, but it's, the most important cases that break down 6-3. But I actually don't even think that's true, because I think often in the media what are depicted as the most important cases are the ones that are 6-3. And so it becomes a circular definition, because there are many cases at the beginning of a term that court watchers will say, now that is one of the most important cases. But when it comes out, to be one in which there's a mix of different jurisprudential philosophies kind of going different ways, all of a sudden it loses its status as one of the most watched or most important cases of the term. And, that happened last term in cases involving guns. It's happened recently in cases like FDA versus Society for Hippocratic Medicine, the abortion pill. I mean, so there have been many cases of social media cases.
Fulton was a case of that.
Fulton is an example. So, I think the narrative, personally, I don't think the narrative is accurate. And that's not to deny that there are some cases, like I said, there were 6. It's not to deny that sometimes that doesn't happen, but it's not the overarching story of the court.
Let's talk a little bit about what you say in the book about the role of the judge. So you start with some examples of what we might stereotypically think of as an ideal judge. And Solomon is one. You talk about some of the other great lawgivers that are featured in the Supreme Court. And then you contrast that with what you think the appropriate role of a Supreme Court justice is in our country. So talk a little bit about why Solomon's getting it wrong, at least if he was going to be a Supreme Court justice.
If he was a Supreme Court justice, if he was a nominee, he'd never be confirmed. Because Solomon and all of the people who we think of as the great lawgivers of history, and we have great lawgivers of history like, Confucius and Solomon and Moses depicted on a frieze in the Supreme Court's courtroom. The wisdom that they had came from within. So, Solomon adjudicates the famous dispute between the women who claimed that they were both mothers of the same baby. And he finds a way out and he says, okay, we're going to split the baby, knowing that the real mother of the baby would not allow the baby to be cut in half. And his gambit works and the real mother of the baby is identified. We think of the ideal judge as one who has the kind of wisdom of Solomon, who looks at a case, who looks at the facts and says, this would be the most just result. This is the person who should win. This is the result that accords with my sense of justice. And there are certainly people who are very wise, and if Solomon were around, I'm sure that I would take many questions and many disputes to him, right? But the role of a federal judge is defined by Article 3 of the Constitution. And we are not free to just exercise our innate sense of justice or rely on our own sense of wisdom. In the structure of our government, we have a very defined role, which is to decide cases in accordance with the law. And so I say in the book, I give examples of justices who have openly said that results in cases were at odds with what they thought that the fairest or the most just result was. Justice Kennedy said that about the flag burning case. He thought that flag burning was protected by the First Amendment, even though he hated the result of that case and thought flag burning was horrible. Justice Scalia said the same thing. Justice Sotomayor has said that about cases involving, the crack cocaine disparity and sentencing of Black defendants who were sentenced to disproportionate sentences because of that crack cocaine disparity. So it just isn't the case, even though I think that lay people, I tell the story in the book by framing it with a conversation that I had with an aunt. I think that lay people often expect the court to do the right thing, thinking that the right thing is kind of that Solomonic exercise of judgment. But in our system, the right thing is what we think the law that is the product of the democratic process requires.
You wrote before becoming a justice about ways in which, for example, you view the death penalty as immoral, and yet you've participated in cases like Tsarnaev that involved death penalty issues. So talk a little bit about what you said in the book, that you view it as it would be a problem if a judge, for example, participated in those cases, but then cheated and tried to bend the law in a particular way based on their personal views. How do you try and resist that in yourself as you're adjudicating these cases, and why do you think that's important?
Yeah, so I would not normally share my views about any particular subject now that I am a judge, but I did publish an article about the death penalty before I was actually even a member of the bar. It was something that I wrote when I was in law school with a professor. And what I say in the book, because drawing on this article that I had published many years ago, is that a conflict, this actually came up in my confirmation hearings. Senators pressed me to say, and some were misinterpreting my article and thinking that what I was arguing is that you should decide consistently with your beliefs, say about the death penalty or about anything else. But I actually think the opposite, and it's what this article argued was the opposite, that a judge needs to separate personal beliefs from the adjudication of cases. If the judge can't do that, she should recuse and not cheat. Because not everybody shares my view about the death penalty. The death penalty is authorized in many states, and we see many cases. I've seen several emergency applications over the last few weeks from prisoners on death row who are facing their executions. And my job is to ask whether those sentences were imposed consistently with the law. But my task is, assuredly not to ask to impose my views of the death penalty on the parties before it, on the people of the states who have authorized the death penalty in their criminal laws. And so I guess a theme is it's all an act of the will. You said, how do you keep yourself from cheating? I think it would be wrong for me to say I can look for ways and I can exploit arguments and say, I'm going to lean on this argument rather than the other one, even if I think it's a weaker argument, to try to get the result that I want out of the case. I think that's inconsistent with the role of a judge. I think, again, it's an exercise of the will to keep yourself focused on what you think the law requires than what you think would be the fairest outcome of the case. And I guess that might sound a little robotic. I don't think that probably most lay people would find that a very attractive description of a judge, but I think that's usually because they're only imagining that the judge's sense of innate fairness or justice would line up with their own.
When you were first appointed, you were criticized by some on the political left. You've more recently, I think, faced maybe more criticism from folks on the right for a ruling where you joined some of the justices appointed by a Democrat, rejecting Trump's plan to freeze money for foreign aid. You were also criticized when you dissented when the court allowed Trump to use the Wartime Alien Enemies Act for deportation purposes. And in the presidential immunity case, while you agreed with a basic concept, you wrote separately to have sort of a more narrow view in that case. So some have said this means that you are drifting to the left, and I'm curious if you have reactions to that characterization of you, or how you would characterize yourself.
Let's see. I don't think in terms of the categories of left and right, because I think that that's fundamentally at odds with the role of a judge and how the court ought to function. I just think that means that I am exercising my independent judgment to figure out what the best result is. I'm not trying to be on a team. I'm not trying to say I should get the result that people on the political right would prefer or on the political left. I mean, one thing I think, when people ask, what do you think is the most important quality that a judge should have? And I'm just going to take as a given legal ability, right? The ability to reason, analyze, write, et cetera. If you take a bunch of lawyers, all of whom have equal capacity and equal facility with the law, and then you ask me, what do you think is the most important characteristic of a judge? I would say a strength of will. Gosh, I actually don't usually talk about will that much. I don't know, Stephanie, why this is coming out. I think it's strength of character, to be able to be as impervious as possible to what people think about you and what people say about you. Because if you let criticism get to you, or if you let, threats and, a lack of popularity get to you, then you will be beholden to the opinion of others rather than to, your job, which again, I think is figuring out what the law requires.
And you write about in the book, Marshall adopting a black robe as sort of a symbol of judicial humility, and also this idea that judges shouldn't be playing for a team. So maybe expand on that a little bit and how that relates to this theme of judges. I mean, part of your job is, you also talk about every time someone leaves the courtroom, you have made someone unhappy. You have ruled against someone. So it is your job to disappoint people.
Yeah.
I feel like dentists are sometimes in a similar category, but maybe talk about what that's like and how the robe is a symbol of that in some respects.
When I was preparing for my investiture for the Seventh Circuit, I was going to have to give remarks that part of the investiture is the robing. And as you all know, the robe that federal judges wear is black. So I was just reading about the robe and discovered that John Marshall was the one who adopted the black robe first. Before that, when you look at pictures of John Jay, who was actually the first Chief Justice, you see him in kind of the fancy red robes, and that's what English judges used to wear. And Marshall, known to history as our great Chief Justice, chose the black robe because he was trying to separate judges from partisan politics, and he also regarded it as a symbol of humility. So the judge is receding. The judge isn't the flashy one in the flashy red robes. The judge is receding, and they're all wearing the same thing. I mean, he didn't impose it on the other justices, but the other justices soon abandoned the colorful robes that were often, if you see commencement at a college and everyone's wearing the fancy colored robes that represent the universities from which they graduated, that was kind of what judges did. They all moved away from that and gravitated to the black robes. And when you see us sitting on the bench, I mean, first of all, we sit, seniority dictates our seats. It's not like Congress where, you've got like people on the left, people on the right. We're all mixed in and we're all dressed exactly alike. And I think that reflects both the humility and the impartiality of the law. And I think it's a really powerful symbol and a visual one.
So if it's important not to take into account things like opinion polls or what would be preferred by different groups, you have talked about, in contrast to that, the importance of a judge maybe considering prudence in their decisions. I'm just curious, how does prudence come into play for you when you're thinking about cases to grant for cert, or how to handle the emergency docket, or in a merits opinion, or when to write separately? I can imagine prudence will influence how you approach those different tasks in different ways.
It really does. And it's a different kind of prudence. Prudence is required in all aspects of life, right? And certainly prudence and discretion are required of a Court of Appeals judge. And so, I had to exercise prudence at the Seventh Circuit too. But in the Supreme Court, and I think this is because of its position as the highest court, requires different kinds of prudence for which there are not law school classes. There are not law school classes. There's no training as a lawyer in the decision whether to vote to grant cert to take a case. There is no training as a lawyer, for when you become a judge and you have to decide how broadly or narrowly to write an opinion. When you have to decide whether to write separately or not. When you have to decide what kind of language and how sharp your rhetoric should be. All of those things are questions of prudence and discretion. And they are, matters on which hopefully I will continue to become more prudent and exercise my discretion in better and better ways, as I have more and more experience in exercising judgment.
One criticism I think the court has received more lately relates to the interim orders docket or the emergency docket, some call it the shadow docket. There ought to be more prudence exercised about that docket. And I think it's interesting because sometimes the criticism is you're not doing enough. Sometimes the criticism is you're doing too much. Sometimes the criticism is the opinions are too short. We need more guidance. Sometimes the criticism is that you're rushing through these decisions and deciding too much. So I'm curious what your thoughts are about the emergency docket, which is playing an increasingly prominent role in the work that the court does, and I think puts a lot of pressure on the court, not all of which is driven by the court. You talk about in the book, there's a lot of external factors that I think relate to why the emergency docket is the way that it is.
Yeah, so justices over time have commented that when you look at the docket of the court, you will see a reflection of the domestic issues in the country at the time. And I think, you saw that during the civil rights movement. For example, you saw that during the New Deal era. The cases reflect what the concerns of society at the time. And if you look at our docket right now, you see that too, both on the merits docket, but also on the emergency docket. We don't get to pick the emergency docket, so we don't get full control over any aspect of our work, including the merits docket, because we're a reactive institution and we wait for cases to come to us. But because we have discretionary jurisdiction, we can, in the exercise of certiorari, decide what cases we want to take. And if we deny cert, well, nobody, I mean, people might talk for a little while like, oh, wow, I'm very surprised I didn't take that case, but they generally just kind of fade away, and then maybe another case that presents the same issue will come up later. The emergency docket is different because you can't just deny cert, right? Every emergency application that comes, Justice Kavanaugh has said, both publicly and in his opinions, it has to be granted or denied. So you grant or deny, and there will be some judgment of the merits wrapped up in that, insofar as the stay factors are likelihood of success on the merits, likelihood of irreparable harm, balancing of the equities, being another. We do consider cert worthiness so that we're not pulled into disputes that are not involving issues we would be likely to take. So these cases come, and they come fast and furious. We have a very short fuse on which to decide them. And I guess I'll just say, I don't know, maybe two things about the emergency docket. One is that we have no control of it. It's just incoming. The intensity of it is, the docket is not new. There's always been an emergency docket. It's certainly been on the incline, and the intensity of it right now is quite acute. We are, I would say, figuring out the best procedures and working at it. It's new. In the book, I talk about how the court's practices for handling the merits docket evolved over a century, how oral argument took shape, how writing opinions changed over time. And, the interim docket is kind of a new phenomenon. On the writing of opinions thing, I am of two minds about it. Certainly, opinions are the court's most important work product. That is absolutely true on the merits docket, and it makes the court the most transparent branch of government on the merits docket because we have to explain all of our reasoning. We don't just have a vote. We have to show why we voted the way that we did. The interim docket is not a full merits disposition, and if we write too much, it risks becoming one. If we are deciding something just preliminarily, all we're deciding is what is the status quo going to be while the case is litigated to its conclusion. And then at that point, if it comes to us, we will write a full opinion on the merits, describing why we reach whatever result that we reach. It's riskier. I think there are drawbacks to doing that on the emergency docket, just for the sake of making it what I've called a lock-in effect. Once justices write out full reasoning and sign on to a view, it's harder to change your mind later. And if you've made a preliminary judgment, it is by definition preliminary, and one that is subject to change once litigation has run its course and once we have a normal amount of time to decide something with fulsome briefs. These are preliminary, only interim judgments. So I guess, those are the two things I'd say.
So one thing you write about in the book is the difference between judgments and the court's reasoning in an opinion, getting to that judgment, and the weight, how the weight of those two things are different. This is actually something in my Structures of the Constitution class we had talked about as well, and read Lincoln's description of that. I'm curious, so you could speak to that, but also, would you say that there's a different weight in terms of precedential value of a very brief interim orders docket ruling as opposed to a fully fleshed out merits opinion?
Oh, yeah, of course.
Yeah.
I mean, an interim orders docket opinion, I think, represents no more than the standards that it's applying. And the standards include more than the merits. We've said in the stay context that the most critical factors are likelihood of the stay applicant's likelihood of success on the merits and whether the stay applicant suffers irreparable harm. Well, an interim docket order, even if it is accompanied by opinion, represents only that. A merits disposition, by contrast, is only about the merits. You don't win, harm doesn't put you over the edge in a merits determination. It really is just about the merits. And so that's different. Now, an interim orders opinion may bind, I mean, and this is an evolving area, but I mean, it's reasonable to think that it may bind other cases in that posture. Other cases, if lower courts are facing the same question of what are the stay factors, how do irreparable harm and likelihood of success play out in this context? But that doesn't mean that it's a merits determination that has the same binding force of an opinion that's been adjudicated on the merits docket.
I want to talk to you a little bit about originalism, which you write about in particularly the past meets present chapter of your book. So what does originalism mean to you? How would you describe that to just broader audiences?
Say that originalism, it means that words in law, in the Constitution or in statutes as well, where it goes by the name of textualism, that words have the meaning that they would have been understood to have by informed observers at the time. You know, law has meaning, and its words have the meaning that, I'll say this right now, but I do not mean to be endorsing intentionalism, but it has the meaning that those who ratified the law intended for it to have. You know, otherwise it's not really law, it would be gibberish. So the principle that law has meaning, that words have meaning, and that meaning forms the content of the law is what I understand originalism to be.
So this is an audience question that came in that I think is relevant right now, but can you talk a bit about what you see as the relationship between, or differences between, originalism on the one hand and history and tradition on the other hand? Are they the same?
Yeah.
If there's delta, help us understand the delta.
That's a great question, because it's something that has been a matter of debate on the court in recent years more than it has been in the past, even though history and tradition has been part of the court's jurisprudence for a long time. So I would say that originalism is the, as I just said, it looks to the meaning that words had at the time. And I should say also that, you know, as Professor Solomon would say, there's the fixation thesis, and that meaning is fixed at the time. Yes, tell him that I did. That words have the meaning that they would have been understood to have at the time that the text was ratified, and that meaning is fixed. And so the original meaning of words, I mean, let's imagine that we're talking about the original meaning of, you know, free exercise of religion or freedom of speech. We would say that that meaning is fixed, okay? So in that respect, it's immovable, and it is immovable at that moment in time, that the fixation thesis. History and tradition isn't about that moment in time. History and tradition is about how that text, how the content of that law was treated and developed over time. And so I do not take history and tradition to be the same thing as originalism, because it gets at a different question. It's not asking what the law was at the time of ratification. It's asking a different question about history, sometimes history that predates the law, most often in the court's jurisprudence, history that unfolded after that text was ratified. It's often the history and tradition of the political branches, how they understood and implemented particular provisions of the Constitution. And history and tradition, well, I'll stop there. You might have follow-ups.
Well, so there's another question that came in from the audience that said, when you have, so this relates to founding era history, but then I want to go back with you to other uses of history. If you have ratification era history that you have like a lot on both sides, so there's a really strong case on both sides, what do you use as a tiebreaker? How do you approach that sort of situation? Is there a thumb on the scale that would help one side over the other for some reason, or how would you approach it?
One myth about originalism is that it yields a clear and definitive answer in every case, kind of like, you know, Google Translate, you just pop it in and then it spits something out. History can be difficult and it can be murky. And by the way, that's not unique to originalism. That's unique, that is something that's endemic to legal questions. When people look at sources, when they're trying to decide, if you're just talking about precedent and you're trying to figure out what is the meaning required by this particular line of cases, if it makes it to the Supreme Court, it's because it's not clear. It's because there might be competing themes, competing holding of cases that are in the same neighborhood that address the same topic. That happens when you're trying to discern the original meaning of text as well. And I wouldn't say that I have a tiebreaker or that I have experienced the use of a tiebreaker. I think what I have done is just try to figure out, considering all of the sources that are on the table, which is the most persuasive, which meaning is the most persuasive and the most consistent with the evidence that's been brought to bear on the question. And note that originalists will disagree on that answer. You know, Justice Thomas and Justice Gorsuch have disagreed. I've agreed with Justice Gorsuch and Justice Thomas. So, and that's not a sign that of the failure of originalism. That's just a sign that law is hard.
You talk about ways in which, and this relates to what you were just saying, you're not originalist because it yields easy answer or because it can't be misused. It could be misused, but you just think that's the right way to think about law. One question I want to build on with this conversation is sometimes interpretation might not yield the answer in terms of, you talk about, you might agree on the principle, but not how it's applied in a particular case. You were just referring to that. I think another debate that was relevant in your Vidal case is a question of, even if we agree on some of the original principles, there might be disagreement on the judicial test that should be used to implement those principles. So Larry and Randy would refer to that as a type of constitutional construction where you're trying to give legal content to communicative content. And I'm curious if you think about it that way, and also if you have a response to critiques of some originalists that's just, those tests are just made up. If you're coming up with tests, you're just doing something non-originalist as opposed to just looking at the history, like Justice Thomas was doing in that particular case.
So I think this is one of the hard areas of constitutional law, and I'm glad that academics like Professor Barclay are exploring this question. I think the problem is, it is also a myth that originalism answers every question. So originalism can tell you what the meaning of the text is, but not how it should apply in a given case. So the Vidal versus Elster case that Professor Barclay is referencing involved the application of the First Amendment to trademark law, which wasn't really around at the time of the founding. And so you had to figure out whether the court's job was to figure out how the First Amendment applied to trademark law. And if, I mean, in that case, the challenger wanted to trademark the phrase Trump too small. And there was a rule that, you know, the rule that prevented that from being trademarked was that you couldn't trademark proper names. Well, that's a content rule, right? That's content discrimination. So how does that mean? But a lot of trademark is content discrimination. So does that mean that all trademark regulations, all trademark law, you know, has to be subject to strict scrutiny under the First Amendment, or is unconstitutional, you know, because it violates the First Amendment? So you have to figure out, and you can't really ask the original meaning to do that work, because it's a situation that wasn't there at the time of the founding. So you can't say that, like, defamation or obscenity, it's just not encompassed by the First Amendment. So you have to figure out what to do. And the debate in that case was about, well, whether we think of it as construction, you know, like Professor Barnett and Professor Solomon would, or whether you think about it as some other mechanism of adjudicating the case. How do you solve it? And in that case, Justice Thomas used history and tradition and said, listen, we have a history and tradition of allowing trademark of this particular kind of regulation in trademark law, this particular regulation that prohibited trademarking proper names. I didn't think that the tradition or the history actually bore that particular principle out, but I also don't think that we would be bound by it if we did. And so in my concurrence in that case, I was just trying to separate out this idea that history and tradition is the same as originalism, or that it somehow forms the content of the law so that it's binding in the same way as the original meaning. It's not. History and tradition might be a way of limiting the discretion of judges. You know, one might decide that history and tradition should be binding, but it's not because it's the original meaning. It's because that is the test that the judge has chosen to apply. And I didn't think that that test made sense there. both because I didn't think it was borne out by the record, but also because that's just one of many, 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 many trade regulations that can be thought to discriminate on the basis of the content of the proposed trademark. So we're going to need some kind of test, because it's not going to be the case that you can trace, even assuming you could trace this proper names thing back in history and tradition. It's not going to be the case that every single trademark law does have an analog in history. So the court is going to have to adopt a test, I said, like the test that we use for example, limited public forums, to try to figure out how to handle those regulations. Because all 9 justices agreed that it couldn't be that all of trademark law runs afoul of the First Amendment. So that's what I see as the difference between history and tradition on the one hand and originalism on the other. It's a distinction between what the law actually demands, the actual content of the law, and then a test that a judge might apply to try to decide whether a law is consistent with the original public meaning.
And related to that, something you've expressed some caution about in your Rahimi separate writing is that if we're looking for ways in which government actors were regulating at the founding, we just should be cautious to assume that means they were regulating to the extent of their constitutional authority, that they can do that and no more. So
Right.
I'm curious if you want to speak to that at all.
Yeah, so in the Second Amendment, Heller said that the right to bear arms, the content of that right is one that predated the founding. And so when we're figuring out what that right consists of, we consider not just the meaning of the right to bear arms, but we consider what that right entailed, because people understood themselves in the Second Amendment to be ratifying a right that had this pre-existing content. I'm just repeating myself now. So history and tradition is part of that inquiry, and Bruin made that more explicit by saying, listen, when you're going to try to figure out what the contours of this pre-existing right to bear arms was, you should look back to see how it was regulated at the time, because if we see a regulation that is similar, then we can know that it's okay. If we don't see any kind of regulation of this sort of thing, then that's probably part of the right. I think that can be taken too far, because if we think that all regulations have to have, or all lawful regulations have to have an analog from the time of the founding, at a very specific level anyway, then we are assuming that state legislatures and colonial legislatures before that and parliament before that were regulating to the full extent of their capability. And there's no reason to assume that legislatures always exercise all the power they have at the time. And that's particularly so when there would have been no reason for the legislature to confront the particular regulatory problem that a modern legislature confronts in a modern gun regulation.
One challenge that I think is relevant for originalism and other interpretive theories too deals with the level of generality. And so one critique of originalists and of the court when it comes to, say, Dobbs versus Bruin is that in Dobbs we were defining the right at a pretty specific low level of generality, whether or not there was a right to abortion. And in Bruin, Reva Siegel has argued we're defining the right at a higher level of generality to include activity that wasn't protected at the founding. So I'm curious if you have a response or reflections on how do we deal with that critique or concern that the court sometimes can be opportunistic with the level of generality that it chooses when it's trying to figure out meaning based on this history.
I think the level of generality problem is an extremely difficult problem that permeates constitutional law. I also think, and I think that can be difficult even when you're in the silo of one particular right, say when we're interpreting the content of the right to bear arms. I think that it cannot be the case that the right level of generality is consistent across every single provision of the Constitution, because part of the point in determining the right level of generality is figuring out what that particular constitutional provision contemplates. So in many respects, I think the Due Process Clause and the Second Amendment are just apples and oranges, and the fact that the theory of the right to bear arms, as encompassing a pre-existing right, well, deciding what the contours of that right is and deciding what level of generality applies is just a completely different question than figuring out what a completely different phrase, this phrase due process of law, requires. I also think that Ruin and Heller are saying that the contours of the right, or this history and tradition, is actually part of the right. And I just think that the due process clause is something totally different, because all of that is, what's the word that I'm looking for? It's path dependent. Glucksberg, which narrowed the due process clause and imposed the history and tradition test, was trying to rein in the court taking a clause that was very vague, due process of law, and infusing it with substantive rights. Glucksberg was saying, no. The court shouldn't be expanding this phrase, due process of law, with rights, Solomon style, to return to Solomon, that it thinks are just, or that the American public should protect. That's not what this exercise is about. And in fact, one might say that those who signed on to Glucksberg had some skepticism about whether the due process clause should be used in that fashion at all. But as a matter of precedent, we're accepting it and just simply saying, we'll accept that the due process clause has substantive content, that it's not merely a procedural guarantee. But if we're going to have judges in the business of recognizing unenumerated rights, as opposed to an enumerated right, like the right to bear arms, then judges have to be very disciplined about it for the sake of democracy, to avoid the temptation of the judge to impose what the judge holds dear or values that the judge treasures, and say that they limit the democratic process and what the people can choose. So the theory of the due process clause is just entirely different than the theory of an enumerated right, like the right to bear arms. And so while I think the level of generality problem is a very serious one, I do not think it's a problem to have the level of generality be set differently depending on the clause that's at issue.
I'm going to ask you just a few lightning round questions that our students submitted, and then one last substantive question. What's the ideal height of heels a lawyer should wear?
Gosh, I think that totally, this isn't very lightning because I'm not giving you an answer right away.
Yours are very nice.
Mine are probably 2 inches.
Okay.
I don't know, kitten heels and flats can be quite comfortable though.
They really can.
Rothy's can be really nice.
I like Rothy's too. If you were in the Harry Potter books, which Hogwarts house would you be in?
Not Slytherin.
Okay, good.
Gryffindor.
Oh, me too. What's a food you'll never get tired of eating?
Chocolate.
Last non-substantive question, I'll ask you one more. What's your favorite spot in the Supreme Court building? If you wanted to go stand somewhere for a moment, where would you go?
People would see me, so I wouldn't go stand anywhere. I guess my office, because I can hide away. Yeah.
Fair. You've spoken about how in the book and in other interviews, the success of our democratic society rides on our ability to disagree respectfully, and our Constitution bakes in a need for compromise. It precludes a winner-take-all system. And I think right now, in a particularly polarized moment, this is a more important principle now than ever. So if you have any advice for students and professors in the audience, how we can contribute to having a society that can agree in ways like Justice Scalia said, being hard on ideas but not people, and contribute to a society that values the rule of law, what would you suggest?
I would suggest really something as simple as time spent together and time spent with people that you disagree with. I think one thing that I observe that's different today than it was, say, when I was in college or law school or even a young lawyer, is that people are so siloed. And I don't know if this is a function of social media, and COVID certainly didn't help, but people tend to run in tribes only with those who share their set of values, be they politics, be they religion, be they morals, whatever. I think if you don't know people who hold different views, it's quite easy to vilify them. And I think spending time and having respect for and assuming the best of those who disagree with you helps you realize that we're engaged in a common enterprise. I mean, we can't run the country. The country is big. The country is full of people who disagree about lots of things. And if we're not going to try to engage in a common enterprise and engage in the business of running America and being Americans together, the project can't be sustained. So we need to learn how to work together despite our differences, rather than trying to hope that our particular view of the world can stamp out all competitors. It's just not going to happen.
Well, thank you for your public service and for this terrific book, Listening to the Law. Please join me in thanking the justice.
Thank you.